We will go on the record in the matters 24 CF 170, 24 CT 33. State of Wisconsin versus Jacob Jones. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Jones in person in custody with counsel Gabriel Pollock. We're set here today in these matters for two things. First is with regards to 24 CT 33. The OWI third was inadvertently dismissed and read in with the agreement, and I do not believe that was part of the agreement. Is that correct, Mr. Pollock?
Your Honor, I guess I'd spoken to Ms. Rockow earlier this morning, and we had just noted that it had been read in and believed we were here for sentencing in the 24 CF 170 matter.
No.
Understood, Your Honor. I can certainly conference with Ms. Rockow to see how she would like to proceed with that. I guess I'm not sure how the court would prefer to proceed.
Because the OWI third was not a part of the agreement to be dismissed and read in particular because the legislature, as well as the public and the public interest, looks at those matters, the OWIs, very, very seriously. And that was overlooked by.
This isn't your average sentencing today. A father faces judgment for an act that left his own daughter injured. The courtroom is silent, the judge's eyes locked in, and you can feel the tension crawling up the walls. Every detail of the charges hits like a gut punch. Family, betrayal, and a single violent moment this case is about to get raw.
All parties, including the court, when all the multiple cases and multiple things were put on during the plea hearing. So with regards to 24 CT 33, that matter, the court does not allow that matter to be dismissed and read in. And if that affects today and what's going to happen today, then we need to address that, and this matter needs to be reset because, again, the OWI third in 24 CT 33 was not a part of the agreement that was reached between the parties. And that was not the agreement that was recited to the court. If that was recited to the court would not have permitted the agreement and would have proceeded to trial.
Understood, Your Honor. I believe that Ms. Rockow and I can likely come to an arrangement. I just had not done that at the moment, but I think we can likely have that figured out.
All right. So why don't you go conference with Ms. Rockow, and then you're going to need to conference with Mr. Jones because I don't want him to feel rushed, but this matter can all be reset to a different date and time. However, I do understand that this is your last day on the public defender's office in this capacity, and another public defender would need to be retained or appointed.
Yes, Your Honor, I appreciate that. I also know that there are numerous people here in support of it.
The prosecution wastes no time, every sentence sharp, every accusation cutting deeper. Okay. They lay out a history that suggests this wasn't an isolated slip, but a dangerous pattern. The judge's expression doesn't flinch, but you can tell. She's taking in every word. Each fact lands heavier than the last, setting the stage for a punishment that could change everything.
Accommodate this, that would be my preference.
All right, we will briefly adjourn. Back on the record, Sam, appearances as previously noted, the parties have reached an agreement. Mr. Pollock has went over a plea questionnaire waiver of rights form as it relates to 24 CT 33, operating a motor vehicle while intoxicated. Mr. Pollock, can you please recite the agreement on the record after the court is making the formal order to reopen 24 CT 33, because that was not a part of the original, that was not a part of the agreement, correct, Ms. Rockow? Correct. And correct, Mr. Pollock?
Yes, Your Honor.
All right, please recite the agreement for the record.
Your Honor, our understanding of the agreement, if Mr. Jones enters it.
So slowly.
Yes, Your Honor. Our understanding of the agreement is if Mr. Jones enters a plea of guilty to count 1 in 24 CT 33, which I believe is the operating while under the influence of an intoxicant. Count 2 and 3 would be dismissed count 3 would be dismissed and read in. Count 2 would be dismissed by operation of law, or nope, count 2 is not operating while revoked. I thought there was a prohibited alcohol concentrate. So the remaining counts would be dismissed, 2 dismissed and read in, 1 as a matter of law. The parties would join in recommending a sentence of 45 days in the county jail, a fine including the various surcharges of $1,844, loss of operating privileges, and requirement for an ignition interlock device for 24 months.
Where are you coming up with those things? You're just kind of pulling them out of the air?
Your Honor, I think a lot of this was the,
That's not even my IDIP guidelines, which is the lowest, and that's not even the district guidelines.
Your Honor, I guess
Your Honor, I think that we're now viewing these as this is now kind of a global situation that we have here. We're resolving the felony file and the CT file together. The 45 days is the statutory minimum period.
Then the defense fires back, determined to rewrite the story. They paint him as a flawed man, yes, but one who lost control for a moment, not a menace to society. Their words aim straight for the judge's sense of fairness. It's a desperate TUGUV war, and the outcome hangs on which version of this father she chooses to believe.
I think that's appropriate given the recommendations the parties will be making for the felony. We are recommending a lengthy period of supervision. So I think that's appropriate given that level of protection to the public. Also, I understand that Mr. Jones spent 12 months in the county jail, or was sentenced to 12 months in the county jail due to the revocation. So I think that we can also factor that in terms of what's best for the public. The other thing is that there was an IDIP recommendation or offer that was made, of course. He had begun doing that process, as I understand it, according to my file at least. And then of course he was incarcerated. We're coming up with the 45 days because that's the statutory minimum.
Okay, what about the 1844, the 1,844? That's just a random number.
That's the 10th district guidelines for this offense date from the 2023 grid.
But this occurred in July 2024. My July 2024 grid is 1869.
the OWI was February of 2024. I don't think that the guidelines had gone into effect at that point.
You're right. I was looking at the burglary.
Correct.
That is correct.
So the state has no objection to the minimum fine.
All right, okay. Now we're making sense. All right. Okay, so that's the agreement that's been reached, Mr. Jones.
Yes, Your Honor.
Now we're going to move on to sentencing, and we will in fact do a dual sentencing in this matter. We have the sentencing for the operating while intoxicated third offense, and we do have the sentencing in the 24 CF 170 matter in which you did plead.
The judge steps in and the entire room changes. Her questions slice through the legal arguments, her tone unshakable. You can almost hear the clock ticking down to the decision. Everyone is on edge, watching her every move, knowing that the sentence is no longer a question of if, but how severe.
Guilty to 1 count of strangulation, suffocation, 1 count of false imprisonment, and 1 count of stalking. They are all felonies. The court ordered a pre-sentence investigation report. The court has reviewed that report thoroughly. Ms. Bauer, victim witness coordinator, are we going to have any victim impact statement?
No, Your Honor.
And in my review of the case, I did not find any impact statement filed in this case. Is that correct?
Yes, Your Honor.
The only information that I have received from the victim would be the information contained in, I believe, in the complaint.
Yes, Your Honor.
Okay, all right. Ms. Rockow, argument and sentencing recommendation, please.
Thank you, Your Honor. The state has considered the material in the PSI, and of course, all of the facts and evidence in this case very carefully, and is joining the defense in a recommendation to the court for an imposed but stayed prison sentence. Specifically, the state is recommending that Mr. Jones be sentenced to an imposed but stayed sentence of, as to count 3, 2 years of initial confinement, 2 years of extended supervision, as to count 6, imposed and stayed 2 years initial confinement, 2 years extended supervision, and as to count 7, imposed and stayed 1.5 years initial confinement, 2 years extended supervision, all to run concurrent to each other, as this was one incident. I think that it's appropriate that they do run concurrently. In reviewing Mr. Jones' history, he does not have a violent history. He has a history that looks like somebody who uses alcohol and makes bad choices when he uses alcohol. He is fairly young, and I think as evidenced by his criminal history and by what was outlined in the PSI and the facts of this case, he has a lot of rehabilitative needs. But the state disagrees that there is an obvious pattern of serious conduct that the defendant has engaged in, which was mentioned in the PSI. The only pattern that I see is that he has multiple OWI convictions. So that suggests a pattern of substance use. In considering probation first, I think that based on his record and based on his rehabilitative needs, the safest thing for the community is to indeed rehabilitate Mr. Jones within the community. I believe that probation can adequately supervise Mr. Jones within the community and do that in a way that will protect the community, that will protect the victim as well. He'll have to engage in day-to-day real life.
What about 22 CF 012? And now there is a material fact that I have just discovered because DOC put it as 22 CF 212. Yes, it was dismissed and read into other cases, but there is a very similar fact pattern that was charged out by the district attorney's office. Very, very similar, where we had there were allegations of strangulation, suffocation, battery, disorderly conduct. Perhaps that's where we're getting the pattern from the DOC agent.
And I agree with Your Honor. I think that that is the pattern that's the only pattern that they could be pointing to.
Then the gavel comes down figuratively and emotionally. The judge delivers the sentence with precision, each word falling like a stone. The father stands still, his face showing the weight of what he's just heard. It's final. It's done. If this left you hooked, hit that like button, subscribe, and get ready for the next courtroom showdown.